May it please this honorable court, Your Honor, my name is Hanimar Binti Harun, the counsel for the appellant, and this is my legal counsel, Ms. Nur Shazwani Sahira, together with me, the counsel for the respondent, Ms. Nur Afrika and Ms. Christina. Before I start my submission, I will briefly explain about the fact of the case. The respondent and the first appellant is a married couple with 3 children. They are both legally married under the California law. The respondent and the first appellant mutually agreed to transfer the asset, including the inheritance, to creating the family trust for the Kimball Family Trust. On 26 February 2014, there are 2 trusts was created. The first is account trust that was had for the bank account, and the second is the Journey Trust that was had for the Journey Kerjasama Secara Berhad Company. After the 2 trusts was combined, they created the Kimball Family Trust and the Taqwa Trust, including the 2 initial trusts. On the 19 March 2014, the respondent and the first appellant acquire a land that was called the Daerah Sepang. On the around 10 January 2017, the first appellant was appointed as the director of the company.
She then just proceed to what is the appeal about today.
Okay. Thank you, Your Honor. My submission is that the respondent has failed to establish his case to grant for the Mariba injunction. I submit that the respondent has failed to establish his case before the court has granted the Mariba injunction. May I assist Your Honor to refer to the appellant bundles of authorities, page 2. According to Order 29, Rule 1 of the Rules of Court, injunction can be granted by the court. The injunction in civil litigation is for the protection of the parties' right before the judgment of the case. The Mariba injunction can be made by the application of the Mariba injunction can be made of the application and supported by an affidavit. But in the case of urgency, the Mariba injunction can be made by ex parte. Referring to the case Biasa Mas Sendian Berhad, Your Honor, may you refer to the bundles of authorities tagging A2, page 6. In this case, the learned judge has made error in his findings. In this case, the learned judge has made error in his finding regarding the good arguable case, and the learned judge also made error in his findings of the
How do you prove a good arguable case, counsel?
good arguable case. Refer in the case of Toyota Susho in the bundles of authorities, page 26. Arguable case. A good arguable case is when there is an issue arise and the issue was left unresolved, and it only can be solved when the trial is conducted.
So how does it apply to our case today? Is there a good arguable case or not based on your submission?
The respondent has no good arguable case as he has no cause of action, as he is not a trustee or a guarantor of the trust. He cannot apply for the Mariba injunction.
Counsel, when you said that he is not a grantor or the trustee of the trust, which trust are you referring to?
The Taqwa Trust,
The Taqwa Trust.
the latest trust.
Okay, what is your proof on that?
The Taqwa Trust consisting of the Journey Kerjasama Secara Berhad, which is the first appellant is the director of that company. And the beneficiary is their children, and not the respondent.
Right, counsel. You said that the respondent does not have cause of action, correct, against
Yes.
the appellant. Okay, but the mere existence of the trust itself was created based on the proceeds of sale of property, which belonged to both the respondent and the appellant while they were still married. Do you agree with me? So is it not how can you now reject that the respondent does not have a cause of action if there is also a respondent's share in the proceeds of sale of their property? They were married, correct? So the property that they sold in creating the trust, the initial trust, okay, were from the property that they acquired during their marriage. So isn't that a share of the respondent as well?
Yes, but the respondent has no cause of action in order to apply for the marital injunction.
I just gave a question to you that don't you agree that the fact that they were married, okay, they have property, okay, jointly acquired property during their marriage, okay, they used that property, they sold that property, okay, and they created these two initial trusts. Okay, so the trust was created based on the share of proceeds of sale. Half of it perhaps might be the respondent, belong to the respondent. So don't you agree that the respondent has an interest, thus having cause of action in this case?
The respondent do have interest on the trust, but he on
How
the
can he
part-
not have interest if his property is also used to create the trust?
yes, he has the interest in the trust because of the properties. But for the marital injunction, he not fulfill the requirements for the application.
It is not fulfill the requirement. Can you explain the requirement for application of marital injunction?
There are three, which is first a good arguable case.
How can he have a good arguable case?
He must prove that because he applied for marital injunction to freeze the asset.
Sorry, he must prove.
He applied for the marital injunction in order to freeze the asset.
Yeah, that's
to avoid
what the respondent is trying to make.
to
Okay.
avoid
But you say that he didn't fulfill the requirement because why?
because he did not.
Just now you agreed that he has interest in the trust. How come you're saying now that he has not fulfilled the requirement? If he has interest, then he has a claim. Would you agree with that?
The trust on the journey kerjasama secara berhad the company, but the director of the company is the first appellant.
Doesn't matter who is director counsel. If someone has an interest in that particular trust, be he the grantor or the beneficiary, then he has a right to question the properties under the trust. So if you are agreeing with my question just now, whether the respondent has interest, you say he has interest. Is that your stand?
He has interest, but not in the Taqwa trust, in the
He has
the
interest.
recent trust.
But
The
are you
previous-
saying that Taqwa trust exists? It doesn't seem so in your written submission.
Previously they have account and journey trust, but they want to create a family trust.
Okay.
So
They have
in-
two initial trust counsel.
yes.
Okay. Account trust and also journey trust.
Yes.
Okay. So you wanted to say that from these two trusts, they wanted to create a new trust.
Yes.
That's so Taqwa trust.
Yes.
So
Right.
does the respondent has any interest in any of the trusts?
Respondent, no, they have he is not having interest in the trust.
But the trust was created based on the proceeds of sale from property they had when they were still married. So when husband and wife has property, it is considered as jointly acquired property during marriage. So if the trust was created based on the sale of property, acquired during their marriage, it means the husband at least have a share. How can say that he has no interest. Do you require extension of time, counsel? To answer my question.
I would like to the extension of time.
Okay, 1 minute, 1 minute.
Can you repeat the questions?
I'm asking you because you keep saying that you keep saying inconsistent things. Previously you said that he has interest. Now you say he has no interest on all trusts. Is that so? My
Yes,
question
yes.
is, if the trust was created based on the property they had during their valid marriage, okay, then when the husband and wife get married, they acquire property. The property is jointly acquired property during marriage. Okay, so both husband and wife has interest. So if the trust is created based on sale of property of their property acquired during marriage, doesn't the husband also has a share, just having interest? So if that is the answer, okay, do you agree or not? What is your answer on that? And if you disagree, why? Do you agree that the property is their jointly acquired property during marriage?
During marriage, yes, there are properties jointly married. You don't live for them.
Yes. Then,
So he does has
if
interest.
the trust is created based on the sale of receipt of his and her property, it means he's the grantor. He has interest. Your time is up, by the way. You require more time. You only have extension of 2 minutes, Marcel. Okay, if you require more, then marks will be deducted. Okay. So I'm asking you whether you wanted to ask for extension of time to continue answering, or do you want to conclude now?
Okay, I will conclude now. The respondent in this case is applied for the marital injunction application, and he did not fulfill the element of the marital injunction to be granted to him. So I submit that the respondent failed to establish his case before the High Court in order to granting for the marital injunction applications. Thank you. Thank you, Your Honor.